Several of you know that I've been working on a book for about 5 years on this topic, or related to this topic. The kind of the center of my practice is really succession planning, organizing farms, getting them ready for the real world and also for eventual succession, and including estate planning and business organizations and basically all of the above. So I've been working on this book, and a couple of years ago I acquired a partner in that effort, Christy Brecken, she's at OSU, she's an OSU professor, she teaches a class on agricultural law. And she and I've been helping her with that class, and she's turned it around and helped me with this book. And so the good news is that I've got the final draft sitting in my briefcase back there. It just came out a couple days ago in last draft form, and the projection is in the next week or so it's going to go public. It's going to be published by Oregon State, and it's not going to be like a book that you buy at the bookstore. It's all going to be electronic, which is the new way of doing things. The reason I mention it is in the book itself it talks about conservation easements, and it talks about how they can be a part of an overall succession plan, estate plan. And we don't have enough time today for me to hit on all of those elements. I'm just going to get you kind of looking at the tops of the mountains related to that today, this afternoon. The reason I mention it is if you want me, when it comes out, to send you the information on how you can get the book, I will do that if you will email me and say, I'd like to see the book. Okay? So on this handout here, you notice on the back page there's a shameless advertisement about what we do at the firm. We have this team that's organized to help people get organized and do their estate planning and all that, and handle basically everything else you run into with a farm. Down there in the bottom left-hand corner, you'll see my mugshot, and you'll see my email address. Okay, so if you want to see the book when it comes out, just shoot me an email, say, Joe, will you send me the book, and when it comes out, and I'll do it. Okay, so that will expand on a lot on what I'm going to be talking about here just over the next few minutes. Okay? So that's that. So we're going to be talking about conservation easements. Nellie's really, hopefully she shows up here in a few minutes, because she's really going to get in more into what we call the weeds about them, and talk in particular about these programs that are in place now to help with the whole thing and how they work. I'm going to stay at kind of more the 30,000 foot level, the attorney level, if you will, and I'm going to talk about easements, and then I'm going to talk about this subcategory of easements we call conservation easements. And the reason I'm doing it this way is I get a lot of these blank stares from clients when we start talking about conservation easements, like, well, so what are you talking about? How does this work? And so I'm going to give you kind of the presentation I would give a client about easements and conservation easements and how they all fit together. Okay? So here we go. There are two kinds of easements. Again, this is all lawyer stuff. Only lawyers can really appreciate this. There are two basic categories, and they are appurtenant easements and easements in gross. This is a dichotomy that dates back to England, probably dates all the way back to Roman times. You may know that when we threw England out after the Revolutionary War, we turned around and adopted all their laws. And that became the laws of America, especially property laws. And frankly, after they threw the Romans out, they went back and adopted all the Roman laws. So most of this really goes back all the way to Roman times. And this is an example of appurtenant easements and easements in gross. And it's an important distinction for you to understand when you're talking about conservation easements. So this is an appurtenant easement. It benefits what we call the dominant tenement or the dominant estate. So somebody's house is up here, and here's the road. So you got to get to the road to get the groceries, right? So this guy needs an easement across the servient tenement, the one that's subject to the easement, across his property to get to the road. The thing about this is it's appurtenant. That's important for lawyers. It means it's connected to this land. It's not connected to the guy who lives in the house. It's connected to the land, okay? So it's the land that benefits from the easement. And that guy just happens to own the land, okay? This easement over here, that's Union Pacific Railroad, or Burlington Northern, as the case may be. Most of their railroad tracks are sitting on easements. And it's an easement that doesn't benefit any particular piece of ground. It benefits Union Pacific Railroad, okay? And they're back in Omaha. So that's an example of an easement in gross. So an easement can, as we lawyers say, run in favor of or benefit either a piece of ground, or it could benefit a person, it can benefit an outfit, it can benefit a company. Separate, unrelated to the ground next door, okay? Next slide. Oops, went too far. Okay, so here's an example. You give a neighbor the right to cross your land to get to the river so he can run a pipe there to draw out irrigation water to put on his land. That's an example of an appurtenant easement. It runs in favor of his land for a particular purpose, to get water from the river up to where his land is. So, the deal is that the neighbor sells the land, the easement stays with the land. It doesn't go with the person. So, the next guy who owns that land, he gets to benefit by that same easement. As we say, it runs with the land. So, and there's Nellie. Thank you. There she is. She made it. So that's an appurtenant easement. It runs with the land and it benefits the owner of the neighbor's land regardless of who owns the land. Okay? Next slide.
Can I ask you a question about that?
Yes.
Okay, you have the house up here that needs the easement,
Yeah.
and somebody comes and buys a section
This land up here.
down from the house,
On this one.
but still on the lighter color,
Uh-huh.
and he comes and buys it. Does he have a right to that easement?
Say that again.
Say somebody comes and you turn a line across the pencil line there,
Yeah.
you turn that purple and it belongs to somebody else, because they bought it.
Okay.
Just that property. They butt up to that easement. Or do they have a right to the easement?
Easements, I don't know if it's going to answer your question or not, but I'll give it a try, okay? Appurtenant easements are drawn or written in such a way that it says right in there, this is a land that's benefited by it, and there's a legal description, okay? And here's the land that's subject to the easement to benefit that other piece, and there's a legal description, okay? And that's just it for the rest of the time. Now, some of those property legal descriptions can change. And I don't know if this is leading to your question. Ownerships can change. It doesn't matter from the point that it's created to the present how many times ownership or legal descriptions change. That easement runs across that land and benefits the other land regardless of what happens to the title going forward. Okay? So this land could break up into pieces. This land could break up into pieces. Easement stays there. It doesn't change. Okay, that's a characteristic of an appurtenant easement. Okay? So again, appurtenant means it benefits whoever ends up owning that land, they get to use it. Okay. So here's a different example. You give a neighbor the right to cross your land to get to the river so he can fish. Okay? So if your neighbor sells his land, he keeps that easement because it's an easement in gross. Okay? So he sells the land, he still gets to fish. He still gets the right to cross your land to do what he always wanted to do with that crossing and to get where he wants to go. It doesn't run with the land because it's not appurtenant to any particular piece of property. It's personal to the neighbor. Okay? And that would be true like of those railroad tracks back there. Okay? Let's say Burlington Northern buys out Union Pacific Railroad. Burlington Northern ends up with that easement. Okay? So it's because it's not tied to a particular piece of ground. It's an easement in gross. So why is that important? Let me go a little further. Another dichotomy. Easements can provide a use or they can restrict a use. Okay? This picture is a good one. I didn't come up with this. Somebody in my firm did. But you see where these pipes are? You see where it's all bare right there? That's an example of probably a pipeline easement where, I don't know, Northwest Natural Gas or somebody has that easement to run their pipes down there. And so that's an example of a right to use your land for a use, like a road or a ditch or a pipeline. Okay? You see right next to it here, there's no trees, there's grass. That's an example, it could be an example of restricting a use. You can give someone the right to insist that you restrict your use of your land in some way. And this one could say, well, this runs in favor of maybe let's say Northwest Natural Gas again. It doesn't allow them to put their pipes over there, but it says, but you can't ever let any trees grow there so that we can get our cat down there if we need to fix that pipeline. Okay? That's an example of restricting a use or requiring a particular use of that land. Okay? So two dichotomies there. Any questions about that one? Yes?
Can you have an easement where it's non-transferable and revocable?
Can you have an easement that's non-transferable and revocable? Yes, you can. It has to say that right in the easement, but you can. You can also make one that's non-exclusive. Kind of into the weeds there, but you can say, yeah, your neighbor can use this road, but I can use it too. Okay? But that's not the dichotomy we're worrying about today. The one that I'm talking about today is like this, and the vision of a appurtenant easement versus an easement in gross. Okay? If I can call up the next one here. There we go. Okay, conservation easements. Let's put that together now. So what is a conservation easement? Conservation easements are easements in gross. Okay, they're not tied to a particular piece of ground where you've given someone the right to insist that you restrict your use of your land for some reason, like that strip of grass. Okay, that's what a conservation easement is from a lawyer's perspective. Okay? Okay. For purposes of estate planning, there are two types of conservation easements. One, those given in return for consideration, i.e. money, or something like money, and those given as a charitable contribution. Money is kind of easy to figure. It's money. Okay, you get something for it. In return for that easement, you replace the rights that you're giving up with dollars and cents that go hopefully in the bank and you don't go spend. Okay? So it hasn't really changed your estate any, value for value. The estate value stays the same. Those given as a charitable contribution, different kettle of fish. And that's the one that a lot of people are looking at these days. So, what's the tax effect of a charitable contribution? There are two. One, it can result in a deduction on, if I say that year's income tax return. Typically, that's where a contribution ends up. Nellie's going to talk about the fact that you can take charitable contributions for conservation easements over a period of time, because there's a special statute on that. Or it can reduce the value of your taxable estate for purposes of calculating estate taxes due on your death. And that's the one where we're getting a lot of discussion. Okay? That's true of any charitable contribution. Reducing your taxable estate by making a charitable contribution. So, here's how it works. When you die, all of your assets will be valued. Everything you own. The sheets, the silverware, the life insurance policies, the annuities, the land, all your personal property, and everything you die with your name on it gets valued. Your land will be appraised to determine its fair market value at the time of your death. It's called a date of death valuation. Okay? Your total assets with that date of death valuation minus your total liabilities on that same date will be referred to by your lawyer and your tax accountant as your taxable estate. That's a term of art. Taxable estate. The value of your taxable estate will be used to determine whether your heirs need to file an estate tax return and how much, if any, estate tax might be owed. So that's a critical number. Okay? Figuring out whether to file an estate tax return. Fact is, if you're in Oregon, you're subject to two separate estate tax systems, federal and state, and they're totally disconnected. Okay? So, the thing is, right now, though, I think it has a sunset provision that goes out to a few years, but right now, the federal estate tax, I call it exemption, sometimes folks refer to it as exclusion, is $11.4 million per individual. What that means is, if you have the proper kind of estate planning or estate plan put together, the right kind of documentation, you can protect up to $22.8 million of value for a husband and wife doing an estate plan from federal estate taxes. That's a lot of money. Okay? So right now, we're not worrying that much about federal estate taxes for most folks. Okay? However, Oregon disconnected from all of that years and years ago and hasn't changed its exemption since. And its current exemption is $1 million per individual. So the total amount per couple that we can protect without anything else going on is only $2 million. I say only $2 million. I get to see a lot of this, and it's just amazing how difficult it is these days to not have at least $1 million worth of assets when you add all those things together. Okay? So it's the Oregon estate tax exemption that most people are planning for with their estate planning currently. So what this means is that the taxable estate number, if it's over $1 million per individual, you're going to end up paying estate taxes. So one of the draws for conservation easements, or the arguments in favor of doing them, is that it might reduce down your taxable estate below the estate tax exemption limit, or at least reduce your taxes if you go over that limit when they go to figure your estate taxes. And that will depend on what that property is appraised at the time that you die. Okay? So Ellie's going to get into a lot more detail about what some of the options are here in just a minute. But this is what I want to leave you with. Estate succession planning is a team sport. That's what I say to all my clients. And you don't want to try this on your own. You've got to have some help. So it's you, an experienced estate planning attorney, your business lawyer, sometimes it's the same person, your CPA, and your financial advisor / insurance agent, because we sometimes have clients, the insurance agent is really the financial advisor. So that's the team that you need to put together if you want to figure out whether this is going to work for you, whether it's going to help you, essentially just how to put together an estate plan. Okay, again, that's just the mountaintops. Nobody's going to get into some more detail. Yes?
How about if you have all your assets in a family trust?
Putting your assets in a family trust doesn't change anything that I've said here. Yeah. If you have your assets in a trust, they'll value those assets in the trust. So putting them in a trust doesn't make them exempt from estate taxes. Putting all your assets in an LLC doesn't change anything either. What you end up with, if you put your assets in an LLC, you end up with the membership interest in that LLC, which is equal to, the value of which is equal to the value of the assets in the LLC. So there's no way to kind of get around it. Good question.
One thing you didn't address is Oregon's, natural resource exemption for ag and enforcement.
Oregon has what's called an Oregon Natural Resource Credit. Okay? And how that works is if you've got, you have to have more than 50% of your assets in what's called a natural resource asset. Okay? And then the relationship, the ratio basically between that and all your other assets will, through a kind of a complicated calculation, determine whether you can get a credit back for some of the estate taxes you would otherwise owe if you had something other than farmland, something other than a natural resource asset. Natural resource assets are basically farmland and cattle right now.
And I'll go into that a little bit more too, Joe.
No, he's going to talk about the natural resource credit. Okay. Thank you.